Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. The life cycle of every divorce case, every custody case, every family law case goes through certain things. There are multiple court appearances that could occur in any given family law case. A lot of times litigants are sort of hot to trot to get before the judge to argue their position, to state their case, to tell the court why they're doing what they're doing, because they're sure that if the court would just listen to them for 5 minutes, the court would say, oh, of course you get the custody and you go to jail. That's what they think is going to happen. My friends, that's not what's going to happen. That's not realistic. That's not how it works. The court is very deliberate in making decisions regarding children, and gives itself the opportunity to take a lot of things into account in order to make a fair decision. A decision that's not only fair to the parties, but promotes the best interest of the child. Don't be surprised, therefore, if in the first couple court appearances, you don't get to necessarily argue your case. Arguing your case and presenting evidence and witnesses, that's for trial. That's the last item on the life cycle list of the case. That's the last thing that goes on. Before that, you may have other court appearances that don't go to that at all. There may be a court appearance which the judge uses simply as a status conference to find out what the case is about, what the issues are going to be in the case. What will we need time for? Do we need a trial on custody, parenting time, support? And maybe schedule that down the road. But the first thing might just be a status conference so the court has some idea of what the issues are. There may be other court appearances too. There may be status conferences. There may be multiple such conferences. There may be settlement conferences where the court brings the parties in to decide, can we resolve the issues before going to that trial or that evidentiary hearing? And then, of course, there may be an evidentiary hearing where witnesses are called, exhibits are introduced in the evidence, transcripts are brought, experts come in. All of these things as part of the attorneys preparing the case. Each and every single one of these things may be part of what goes on, but don't expect that all of that's going to come in the first case and you're going to do it. A lot of people, I've heard this so many times, and other firm directors have told me that they've heard this complaint from their clientele. People say, this is a simple case. Should have been one court appearance and that's it. And now I spent $4,000, $5,000, $6,000 and haven't even been before a judge yet. People, that's not a complaint. It's not a legitimate concern. Why? Because there's a life cycle to these cases. And this is how it goes. And the court doesn't immediately run to the surgical procedure of a trial before it tries some preliminary things, some less invasive things, some conservative management of your case. So don't be all offended if you spent money, you've already gone through your retainer, and you know what? You haven't even been before a judge yet. Going before a judge to argue the merits of your case is the last thing that's likely going to happen. There's going to be a lot of preliminaries that work up to that beforehand. And if you're doing custody litigation, you have to prepare yourself for that. And that's why we provide videos like this, so you can be prepared, so that you can know these are the steps in the process. The process will work for you, but you have to let it go through its steps first. If you have any questions about that, reach out and we'll be glad to help you out.